Now let's discuss this further with House Justice Committee Chair Gerville Luistro. Good evening to you, Congresswoman. Welcome to the big story. Can you hear us?
Good evening, Ses, and good evening, Sean.
Well, first of all, Congressman Suntay's remarks were struck off the record, right?
Yeah, that's correct. And that is why we received a motion to strike out from the record that manifestation, which was supported by the majority of the justice members.
Should he be brought before the Ethics Committee? Should there be an ethics complaint?
Well, it depends really on how the justice members are taking this incident in the Justice Committee today, no? So it depends really on how the colleagues are appreciating or taking what happened in our hearing today.
What about your own assessment? I know we're digressing from the meat of the topic today, but it was really, out of this world, out of order.
It has been my intention really to maintain proper decorum in the proceeding of these impeachment complaints, no? And I personally find the manifestation of Congressman Suntay as uncalled for, no? And that is why I promptly entertained the motion raised by the Honorable Zamora, which was supported by the majority of the members present this afternoon. Yes, it is unbecoming. Yes, it is uncalled for, but from my end, I am opting to focus on this impeachment process rather than delving too much on the manifestation of the Honorable Suntay.
Well, his comments aside, what would be your assessment so far of the proceedings?
Well, I'm actually satisfied with the way the impeachment proceeding is going on. As a matter of fact, we were able to conclude our deliberation on the sufficiency in substance of the third impeachment complaint. And we only have one left for tomorrow in as far as the determination of substance is concerned. That is the fourth impeachment complaint. And considering that they have similar grounds, I anticipate that our proceeding tomorrow will be shorter than the one we had today, no? So as to the progress of the deliberation, as chairperson, I am satisfied with the way the impeachment proceeding is going.
And so after finding if both complaints are found to be sufficient in substance, you now go to the main, you will allow the VP to defend herself as well.
Yes, what specifically says what will happen on the assumption only that the third and the fourth impeachment complaint will be declared as sufficient in substance. The Justice Committee will proceed to issue to the Vice President for her to file her answer within the period of 10 calendar days. And then the copy of this answer should be furnished the complainant. And from receipt by the complainant, they are likewise given a period of 3 calendar days to file a reply, which must be furnished as well to the Vice President. And from that point, the Vice President is likewise given a period of 3 days to file her rejoinder. That is in as far as responsive pleadings are concerned.
And personal appearance is not required?
It is not required in the sense that appearance is part of due process. It is therefore not mandatory. And if she will not be present in the hearing, it will be interpreted merely as a waiver of her right to be present during the proceeding.
But you would enjoin her to defend herself before the committee?
She will
Should you
be,
find both complaints sufficient in substance?
well, if both complaints will be declared sufficient in substance, definitely the during the hearing proper, no, on the assumption as well that there is a finding also of sufficient basis that support the impeachment complaint. So we go to step 4, that is the hearing proper, no. Definitely we will be issuing notice to the respondent on her supposed appearance on the given dates for the hearing proper. But again, this is a prerogative that belongs to the respondent. So whether she comes or otherwise, it will entirely depend on her judgment. It will not harm her right as a respondent in the impeachment proceeding. At the most, it will just be interpreted as her waiver of her right to be present.
And if she does waive her right to attend and be present there, Congresswoman Luistro, does that mean her attorneys can speak on her behalf, or should we just rely on the paper filings?
As far as the proceeding in the Justice Committee is concerned, no, uh, it is only the members and the parties who are allowed. So the lawyers can attend, but their participation is limited to assisting their clients. Their actual participation in behalf of the client or the respondent at this point in time is not allowed in the proceeding before the Justice Committee.
I also caught this part in your press con after that long hearing earlier today, Congresswoman, wherein somebody in the media was asking you about the voting. How will that go? Is it true that you have to vote all or nothing on the grounds?
That is correct, because we will be voting on the entire impeachment complaint. It's either we vote in favor or not in favor of the sufficiency in substance of the impeachment complaint. We did deliberate on each ground. That is only for the purpose of giving the justice members a better and complete perspective for them to be able to exercise their judgment in determining sufficiency in substance.
But would it be all or nothing per complaint? All or nothing combined yung
For
complaint?
the entire, it will be per complaint. All or nothing per complaint. So what's gonna happen tomorrow after the conclusion of the deliberation on the fourth impeachment complaint? We will be voting on the sufficiency in substance of the third impeachment complaint. And after that, we will be voting on the sufficiency in substance of the fourth impeachment complaint.
So you will wrap this up tomorrow.
That's what we anticipate.
Now, what about the one-year bar rule as raised by Congressman Tino?
Well, the 1 year bar rule in relation to the setting aside
Yes.
of the complaint endorsed by the group of Kong Tino. It springs from the perceived inconsistency in the decision of the Supreme Court dated July 25, 2025, which expressly provides for February 6 when to file the second impeachment complaint. Vis-a-vis the resolution of the Supreme Court dated January 28, 2026, which implies that from December 2, when the first impeachment complaint was filed, the 10th session day lapsed on January 14, in which case, because of the inaction of the House, that first impeachment complaint deemed initiated the impeachment process, no? It was not expressed, but you can actually imply from the pronouncement of the Supreme Court that by January 15 of 2026, the second impeachment complaint is allowed already. So the thing is, because of this inconsistency, we have to resolve whether it is February 6 or January 15 when the second impeachment complaint is allowed. And we heard it from the justice members. They applied the rule on statutory construction, which provides that in case of inconsistency, the express provision prevails over the implied provision. In other words, February 6 prevails over January 15. So that is the reason why the impeachment complaint of Makabayan Black was set aside by the majority of the justice members.
Now, after voting on the third and fourth impeachment complaints, do you see the need to consolidate these two? Will there be a vote for to that effect as well in the committee?
The consolidation says will happen upon the determination of the existence of probable cause. And that should be the fifth and last step in the proceeding before the Justice Committee. No? For clarity says, and for the understanding of our viewing public, we have 5 steps in the Justice Committee. One is sufficiency in form. Next is sufficiency in substance. Third is the filing of the responsive pleading. Ito yung sinasabi ko kanina na answer, reply, rejoinder. It is also on step 3 when the Justice Committee is supposed to receive all the evidence, including the swearing in of affidavits and counter affidavits.
And hearing
And then
of
on
witnesses.
step 3, not yet, says.
Not yet.
Not yet. On step 3, we have to determine first whether there is sufficient basis that supports the impeachment complaint. If the answer is in the affirmative, if the decision is in the affirmative, that's the only time we go to step 4. Ito yung hearing proper says, which you are talking about, no? Dito sa hearing process, hearing proper, we will be inviting the complainant, the witness, and even the respondent. And then after the hearing proper, we go to step 5. Here, all the members will vote on the existence of probable cause. And the required vote is majority of all the justice members.
Which
Whatever
would
is the
be-
decision,
What is that number? What is that magic number?
we are 39 regular members plus
So-
15 ex officio. It depends on the number who will attend, but it should be 1/2 plus 1 of all the members.
Okay.
Okay. And
No?
going back,
No,
go ahead.
I stand corrected when I said it depends on the number of who will attend. It's actually 39 plus 15 divided by 2 plus 1.
Okay.
Okay.
That is majority of all the members.
So kahit ex officio bilang din pala.
I suppose.
And just going back to the point of Congressman Tino about the one-year bar rule, and not to belabor it, no, Congresswoman, pero do you expect anyone to take anything up with the Supreme Court with regard to how these proceedings have gone on so far, or wala naman?
So far, wala naman akong naririnig. Except perhaps yung setting aside ng complaint ni Congressman Tino, but I think Congressman Joel Chua was able to amply articulate it, that his intention in standing on that position, the setting aside of the complaint of Makabayan Black, is he's just exercising the necessary caution to make sure that the impeachment proceeding is done within the constitutional limit. No? So I think the intention was properly ventilated. And I hope the Makabayan Black understand that intention of the majority of the justice members.
One final question. All these 5 steps, they're quite long. Kaya ba yan in 60 days? And are these 60 days, are they calendar days or session days?
That 60 days says is session days. No? And of course, the definition of the Supreme Court as to the session days is different from the way it was appreciated
Yes.
for a long period of time already, no?
Yeah.
So as to whether kaya ba yan in 60 session days, definitely yes, says kaya yan.
So 60 calendar days na you're in session, just to be clear, as per the Supreme Court.
Yeah. Ano ba yun? Oo.
Para po hindi
pwede yung stop the
magkamali.
clock. Yun yata yung
Yeah.
may problem.
Because Sean, that's the way the Supreme
Correct.
Court defined session day in the
Correct.
recent resolution. You are correct about that. Session days are calendar days for as long as the House of Representatives holds session.
Okay.
Ibig sabihin, kung walang session, you cannot consider that a session day.
Okay. All right. We thank you so much for your time and the clarity that you gave us as to the process. House Justice Committee Chair Gerville Luistro.